Shortly before President Trump began his second term, Chief Justice John Roberts issued a not too subtle warning. The incoming administration might ignore Supreme Court rulings. Roberts was right that the High Court's ruling be discarded, but Trump is not to blame. Indeed, the Trump administration has stated in absolute terms that it will follow every facet of the Supreme Court's decisions. For better or worse, Trump has tied his fate to the nine. Rather, we're witnessing a remarkable revolt in the lower courts, a revolt that the Supreme Court has so far stopped. And this morning, I published an essay on this topic in Civitas Outlook called The Failed Lower Court Revolt. Federal judges in the East Coast and the West Coast, not in flyover country, are blocking nearly every action taken by the Trump administration. James mentioned a number of those earlier. In some cases, judges are issuing emergency orders within hours without even reading the brief. They can't possibly read the briefs that quickly. And through procedural rules, they can insulate the rulings on appeal for up to a month. And due to forum shopping, the courts of appeals affirm these orders. The Trump administration has only one possible recourse, the U.S. Supreme Court. Much has been written about the so-called shadow docket or emergency docket. But the simple truth is that unless the Supreme Court intervenes at an early point, inferior courts can basically have the final say over the executive power. And to be clear, the Constitution calls them inferior judges. Inferior courts sit below the U.S. Supreme Court. And I think, as James mentioned earlier, the Supreme Court's catching on. We now have anarchy reigning supreme by the inferior courts. So consider three lines of cases. First, involving immigration and the power to deport. The case of Homeland Security versus DVD. It's a person's acronyms, not the movie, DVD. It's better than a guy named FGM and AARP. These are terrible acronyms. If you know what FGM is, you're a good person. So DHS versus DVD considered whether the government could deport aliens to a third country, South Sudan. Right on cue, a federal judge in Boston, lots of judges in Boston this year, blocked the removals. You know what happened? There were federal officials transporting these aliens overseas that had to make an emergency stop in Djibouti. Do you know where Djibouti is? It's in the Horn of Africa. And they were held on this base for weeks. They couldn't leave because the judge said you cannot move these people out of the country. So these officers are stuck there in Djibouti with these aliens subject to removal. On June 23rd, the Supreme Court said, no, you have to allow these deportations to proceed. Yet remarkably, this is crazy, within a few hours, the judge in Boston said, well, my earlier ruling remains in effect. Don't remove them from Djibouti. The judge cited Justice Sotomayor's dissent as authority. DOJ filed something called a motion for clarification. Now, what is a motion for clarification? It's basically telling the Supreme Court, WTF, what is going on? And I want to just read this quote. The Boston judge engaged in a lawless act of defiance that once again disrupts sensitive diplomatic relations and slams the brakes on the executive's power to remove people. Only a few days later, the Supreme Court reversed again. Most judges go their entire careers without having a single case go to the Supreme Court. This judge was reversed twice in the span of 2 weeks. The same judge. Even Justice Kagan, not a NatCon friend, I suspect, said, I don't see how a district judge can do this. We just ruled on this case. Okay, the second line of case involving the president's removal power. That's the power to fire people. He likes doing that. Since taking office, Trump has fired a lot of people, the thousands of bureaucrats, people at every level of the government. He's firing everyone. Okay. Now, Congress has passed laws saying that you can only be fired for cause if you do something wrong. But those cases have been chipped away for years. Chief Justice Roberts, in particular, thinks that the executive power, as James mentioned, belongs to the president, and Congress can't cap in his power to remove them. If you work for the president will be able to fire you. Okay. So the court decided a case in May called Trump versus Wilcox. This involved whether Trump could fire members of the National Labor Relations Board or the MSPB. Don't worry what those are. Those are so-called independent agencies, okay? The Supreme Court said, yes, Trump can fire these people. Lower courts take a hint. Yet, a Maryland judge this time in a case called Trump versus Boyle said that Trump could not fire a member of the Consumer Product Safety Commission. Do you even know what that is? That this is such a vital independent agency that President Trump can't fire these people. Again, the Supreme Court said Trump can fire a member of the Federal Trade Commission, right? Or the National Labor Relations Board, these really important agencies. The Supreme Court ruled in Wilcox. What did the Maryland judge do? He put Wilcox in a footnote. It said, well, this doesn't really apply to me. This was a Supreme Court ruling on kind of an interim basis. Wasn't a final ruling. We're not bound by it. Lesson for law students. If there's Supreme Court authority, do not bury it in a footnote. These judges are engaged in these remarkable things that law students wouldn't even do. A few weeks later, the Supreme Court ruled that yes, Trump can fire members of the Consumer Safety Board. This case is the same as Wilcox. There was a dissent, to be sure, but no one defended this Maryland judge who didn't take seriously the Supreme Court decision. The third line of case involves Doge, where my good friend James spent a number of months of his life working on. There's a long-standing rule that says when there's a breach of a contract with the government, that you're suing the government for some sort of damages, you go to a special court. It's called the Court of Federal Claims. It's a Tucker Act. It's a long-standing rule. Why? Sovereign immunity, right? The federal government's sovereign. It can only be sued in certain courts. You can't just walk into your local federal court and ask for an injunction to block funding. That does not work. So what happened? California sued the federal government in Boston. Wait, what? Why is California suing the federal government in Boston? Because as liberal as the Ninth Circuit is, based in San Francisco, the First Circuit in Boston is even further to the left. They have like no Republican appointees at all. There's I think maybe one or two now. This is a court that's far to the left. All right. So, of course, they go sue in Boston, and the federal judge agrees, says, no, you can't cut this funding to education department. Okay? Yet, the Supreme Court rules these cases do not belong in Boston. They belong in the Specialized Court of Federal Claims. That seems to be a pretty clear ruling, what's called jurisdiction, right? The first thing a court asks is, should this matter be before my court? And if there's no jurisdiction, the case does not belong. Okay, California ruling, straightforward enough. At least I thought it was straightforward enough. Another judge in Boston, there must be something in the water up there, I don't know. Wicked, right? I'm sorry, I'm a Yankees fan, I'm going to enjoy this one too much. Another judge in Boston ruled that Trump must pay out DEI funding. This is DEI funding that was deemed unlawful. I swear to you, these are quotes. The judge in Boston said that the California case was, quote, not final, without full precedential force. Again, the judge cited the dissent. The judge is citing dissents from Sotomayor or Jackson as authority. I swear I'm not making this up. So once again, the U.S. Solicitor General, John Sauer, files an emergency appeal to the Supreme Court. I'll read you a quote. He says, lower court free-for-all. Individual judges elevating their own policy judgments above the executive branch and over the Supreme Court. This is not just judges resisting Trump. We saw that during the first administration. That's old news. The new news is they're resisting the Supreme Court itself. This is inverting the hierarchy. They are the lower court. They're not on top of the pyramid. About a month later, the Supreme Court reverses this case called NIH versus APHA. The court split 5-4, and they said, duh, you don't have jurisdiction. This case belongs in the Court of Federal Claims, not in a federal court in Massachusetts. Justice Barrett cast a deciding vote. She, as she often does, split her vote in two different ways. Same old, same old. But she got the basic point right that this case doesn't belong there. Chief Justice Roberts wrote this really weird one-paragraph concurrence. I'm not even sure what he was saying, but he got his 5 votes when he needed to. Okay. Justice Gorsuch, though, wrote a concurrence, joined by Justice Kavanaugh. And when I read to you Gorsuch's concurrence, now, James Clerk for Justice Gorsuch, when he thinks something's important, he's not afraid to mince his words. He will write very sharply. Gorsuch wrote, "When this court issues a decision, it constitutes a precedent that commands respect in lower courts." Gorsuch added, "This court's precedents cannot be circumvented." So in each of these 3 lines of cases, maybe the lower court judges in Boston and Maryland are acting in good faith. I'm just a little skeptical. As the saying goes, fool me once, shame on you. Fool me twice, shame on me. Fool me 3 times, shame on all of us. I think the Supreme Court is telling lower federal judges, especially in Boston, that they have lost the presumption of judicial regularity. And so long as they issue rulings that do not faithfully follow precedent, the Supreme Court will feel compelled to intervene on the emergency docket. As Justice Gorsuch explained, lower court judges may sometimes disagree with this court's decisions, but they are not free to defy them. We should be grateful that the Supreme Court has stopped this failed lower court revolt. Look, I've been critical of the court more than maybe anyone else in D.C., perhaps, on the right. But they got this one right. Chief Justice Roberts seems partially committed to this cause. I think the Chief Justice should worry far more about revolt in the lower courts than resistance from President Trump. Thank you all so much.